Good evening, everybody. Sorry for the delay in getting this video posted. I had a lot of sick kids and didn't have time to record this in between the stomach flus that everybody had. Let's jump right in with tonight's lesson. We are going to be talking about freedom of religion today. First off, your prep work was to send in videos. Everybody did a phenomenal job. Thank you guys so much for doing that. That's going to make this lesson a whole lot more fun because we're going to have some fun things to watch. For this evening, your homework is going to be to do a discussion and to submit videos related to the Second Amendment. Without any further ado, let's skip over to the text of the amendment. Again, this is the First Amendment. We dealt with the second half last class. This time we're looking at Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. And what exactly that means, we're going to dive into using the examples you all have come up with in your videos. This is our first video, and I'm going to play it for you now.
After police found 150 marijuana plants at his home when they were investigating for a robbery. So here's where the story gets really interesting. He's moving with his wife to Michigan to legally grow medical marijuana, and he has a permit for that. And on top of that, he's also a Rastafarian. So he said, quote, "Cultivating my own cannabis is my way of not contributing to the black market and drug dealing tactics. In my natural state, I don't believe I'm breaking any law. I know I'm not harming anyone or causing any harm to the community." So Scott pleaded guilty to one Class D felony count of possession, which means his license will not be renewed next year to grow marijuana legally, which means that his only source of income now is gone. And he also says that he now lost a key aspect of his faith because he actually is a Rastafarian. This isn't just somebody saying that so that they could smoke weed. He truly believes. So now he's essentially making the Hobby Lobby argument. He's saying, why would you be able to take this away from me? This is my religious freedom.
It's an open and shut case. I'm sure Scalia would agree. I'm sure all the conservatives would agree, right? So now look, you can say, hey, Jane, Kyle, we don't agree with you guys on legalizing marijuana. We don't think there should be medicinal marijuana in Michigan. And he was caught in Indiana, so his permit in Michigan, although perfectly legal in that state, does not apply to Indiana. Okay, those are all interesting and fair points. But Hobby Lobby told us that if you have a religious objection, you don't have to follow the rules that everybody else has to follow. You just have to have a legitimate religious objection. And Rastafarian is a religion that's been around a long time. Smoking weed is part of the religion, okay? It is, okay? I'm thinking of converting. But in reality, that is his religion. I mean, it's inarguable. It's inarguable. I can't wait for Scalia to set him free.
Yeah.
So in Hobby Lobby, they say, well, look, I mean, good Christians, you know, if they want to not serve gays, you got a religious objection, you know what I'm saying, right? But this guy, I mean, Rastafarian, does that really count? Yeah, the Constitution says that you can be any religion you like and that you're not going to discriminate against any religion. They've got to set him free. They've got to.
What's so amazing about the Hobby Lobby decision is that if you read Scalia's take on it, he very clearly admits that he's a hypocrite because he says, I'm only going to apply this kind of reasoning to employers taking away birth control from their employees. And he's very specific. And Ginsburg basically responded and said, dude, you're an idiot. You can't do that. Because it doesn't make sense to say, okay, you're allowed religious liberty, but only when I say you're allowed religious liberty, and oh, look, it only applies to the areas where my political beliefs say it can apply. But let's go further here, because just this idea of religious liberty in general, I honestly think it's a little ridiculous, because you only have religious liberty insofar as you're not violating rational secular laws. So for example, do you have does your religious liberty mean that you can tell your employees, I don't believe in vaccination, so you can't get vaccinated? Or can you say something like, you know, because of my religion, I get to sacrifice a goat every day on my front lawn. Well, I get to sacrifice a human. There are religions that have existed throughout history that truly believe in human sacrifice.
Well, the goat was kind of badass, but you lost me on the humans.
But see, that gets, the bigger point here is, I don't think that this guy should be able to smoke weed because it's his religion. I think this guy should be able to smoke weed because you should be able to smoke weed.
Right. Well, so here's my take on that. Of course, I agree with that, and legalize it. Go weed. But you've got to be consistent. You've got to be at least internally consistent, or let's all agree. I mean, national press covering this, everybody covering this. From now on, Scalia, Roberts, Alito, Thomas, all these guys, if they don't free Jerome Scott, they're the world's largest hypocrites. They don't mean religious freedom. They mean only for Christians, only our religion, right? Now, look, Jerome's actually out on probation, so he's not physically in a jail cell now, which actually kind of makes him lucky in some sense, because there's a lot of guys, some guys serving life sentences for smoking marijuana, right? But he does have felony on his record now, and that's why he can't do the business that he was going to do in Michigan, as Kyle told you. So let's do free Jerome Scott t-shirts, right?
I'm all for it.
Yeah, and if you're not going to do that, well, then go ahead and piss off with your Hobby Lobby, okay? Then you don't get to go around telling me, oh, I got a religious objection to gay people. You can't have both. It's got to be one or.
Well, unless they're talking about a different Hobby Lobby case, I don't particularly think they are. I think they're a little off base here. This is a pretty well put together video, but I think that, I don't really know that they know what they're talking about. A laugh track definitely doesn't make it happen. Anybody can do that. Case in point. Can you spot the differences here between the Hobby Lobby case? In the Hobby Lobby case, this deals with freedom of religion as it relates to the ability to basically get contraceptives for your female employees. That's the most famous one that exists. But here, even if it's talking about gay people, the same logic applies. I don't necessarily agree with it. Ruth Bader Ginsburg definitely didn't agree with it. May she rest in peace. But the logic pretty much goes like this. There's an act of Congress from when they were more conservative that gives people the ability to basically defend their religious beliefs so long as they are not running afoul of other things. The government can't force them to practice a particular belief if it's against their religion. This is different, though. And what makes it different is that in Hobby Lobby, the government was forcing Hobby Lobby to practice something that would violate their religion, i.e. paying for contraceptives. But here, the defendant was doing something affirmatively that he claimed was part of his religion. And there's just so much to unpack here. We're going to get through it all in just a minute. First, the case I want to direct your attention to is Prince versus Massachusetts. In Prince versus Massachusetts, the standard for what the government could control under the Free Exercise Clause was established. And essentially what the government held is that they were going to apply a strict scrutiny test. And this is the same thing that they applied in the Hobby Lobby case to determine that this was a violation of the Free Practice Clause. What happens here is that there are 3 separate standards that the government can apply. That the Supreme Court can apply when determining if violating a right is going to be constitutional or unconstitutional. The first, and this is going to be for things that are like entitlements, like a driver's license, things that aren't protected that significantly, is the rational basis test. And this means that if the government has a law that has a rational basis, there's some reason why this law is important, and the action that the government's taken is rationally related to that interest, then it's going to pass muster. No problem whatsoever. Think about something every day, like, hey, if you have too many DWIs, you lose your driving entitlement. Okay, there's a rational basis for that law, and not being able to drive if you have violated that law over and over again is rationally related to that. Important government interest, the important government interest test or intermittent scrutiny is when we have something that's like a quasi-suspect class, like men versus women. If there is a law that is disproportionately affecting women, for example, they're going to apply this intermittent scrutiny test. This is where there's an important government interest and the action taken is substantially related to that test. The common example, substantially related to that interest. The common example with this is going to be firefighter job requirements. The government has an interest, and it is an important government interest, in making sure that the people who are able to do it, who are firefighters, are physically able to extinguish fires and rescue people. Having a requirement that they can lift 60 pounds or 40 pounds or whatever the requirement is substantially related to the ability to do that job. It just so happens that there are going to be more women that are excluded by that job requirement than men. Therefore, we're going to apply this intermittent scrutiny test. When it comes to freedom of religion, though, we are going to apply the compelling government interest test. Under the compelling government interest test, the government has to have a really important reason for why they want to do whatever it is that they're doing. And the action that they're taking has to be narrowly tailored to affect that goal. Interestingly enough, in Prince versus Massachusetts, this has to do with vaccinations. As you can see, this case was decided in 1944, but some 80 years ago almost, what was determined at that point was that the government has a compelling government interest to ensure that the citizens are going to be healthy, to prevent the spread of disease, and requiring vaccinations is a narrowly tailored method of achieving that goal. In Hobby Lobby, the Supreme Court disagreed. In Hobby Lobby, again, under the Affordable Care Act, contraception was required. Contraceptives were required to be provided to female employees free of charge. Hobby Lobby said that violates our religious freedom. The problem with this is an exception existed for religious not-for-profits. And Hobby Lobby was a for-profit company. The Supreme Court reasoned that because an exception exists for not-for-profits with a religious exemption, it is not a narrowly tailored law because it would be easy for the secretary to extend that protection to for-profit companies as well. The rationale is a little different here. So, do I agree that it is possible that there's a freedom of religion claim for medical marijuana? No, I don't. It's unfortunate, but at the end of the day, in effect, what's declared in Prince is that there are two reasons why the government is going to be able to curtail your right to free exercise. While they established the compelling government interest test, they also declare that if you do things that are deemed to be immoral, then you can also not be able to freely practice your religion. The big question to me seems to be, are you harming other people? When it comes to medical marijuana or marijuana in general, that's a good question. There's no doubt in my mind that heroin or something like that is going to be something that's harming others. So if he was producing heroin, it's an easy question. If he's producing marijuana, I don't know. At that point, is it his own use? I don't know. That's something that you guys can discuss in the discussion post. One of the most important things to note here, though, is that there's a massive difference between what happened in this case and what happened in Hobby Lobby. There's just not really a comparison. Our second video is hiding. There we go. All right, let's go ahead and watch our second video.
And the only time religious freedom is invoked is in the name of bigotry and discrimination. I'm tired of it. And experiencing this hearing, and I'm struggling whether I respond or launch into this question as a legislator or from the perspective of a woman of faith. Because I cannot, it's very difficult to sit here and listen to arguments in the long history of this country of using scripture and weaponizing and abusing scripture to justify bigotry. White supremacists have done it. Those who justified slavery did it. Those who fought against integration did it. And we're seeing it today. And sometimes, especially in this body, I feel as though if Christ himself walked through these doors and said what he said thousands of years ago, that we should love our neighbor and our enemy, that we should welcome the stranger, fight for the least of us, that it is easier for a rich man, it's easier for a camel to go through the eye of a needle than for a rich man to get into a kingdom of heaven, he would be maligned as a radical and rejected from these doors. And I know, and it is part of my faith, that all people are holy and all people are sacred, unconditionally. And that is what makes faith sometimes, that's what prompts us to transform, because it is unconditional. It's not about that it is up to us to love parts of people. We love all people. There is nothing holy about rejecting medical care of people, no matter who they are on the grounds of what their identity is. There is nothing holy about turning someone away from a hospital. There's nothing holy about rejecting a child from a family. There's nothing holy about writing discrimination into the law. And I am tired of communities of faith being weaponized and being mischaracterized, because the only time religious freedom is invoked is in the name of bigotry and discrimination. I'm tired of it. My faith commands me to treat Mr. Minton as holy because he is sacred, because his life is sacred, because you are not to be denied anything that I am entitled to, that we are equal in the eyes of the law, and we are equal in my faith in the eyes of the world. And so I just have to get that out ahead of time, because it is deeply disturbing, not just what is happening here, but what this administration is advancing is the idea that religion and faith is about exclusion. It is not up to us. It is not up to us to deny medical care. It is up to us to feed the hungry, to clothe the poor, to protect children, and to love.
Certainly a great speech by AOC. And I think she makes some very good points, but this is exactly what the First Amendment is saying. If we go back to it, Congress shall pass no law respecting an establishment of religion. Expressly, Congress can't decide who's going to get services from the government and who's not based on religion. So while it's a great speech, I think it's a good reminder of what Congress should be doing, but it's kind of one of those things where I'm not familiar with the context of the legislation she was speaking on, and therefore can't give much of a better answer than, sure, this is what the Constitution says. So moving along, this is an interesting one. We will make sure that we can see this. and go.
Okay, so in my last video, I said that the Dobbs decision in overturning Roe v. Wade sends abortion restrictions back to the states, which it does. And I said that that's going to create a race for some really draconian laws, which it already has, by the way. And I said that that's part of the problem, and here's the rest of the problem. Every single state that's passing these really abusively harsh anti-abortion laws is actually violating the Constitution, not because Roe v. Wade has been overturned, because okay, fine. But because under Jewish law, the right to an abortion is, I mean, it's old. It is in every tenet of Jewish law. It's in the Mishnah, it's in the Talmud. It's in everything. And I can back this up with sources if you want. But here's the reality of it. Is the first time a Jewish woman tries to get an abortion, they say you can't because we don't allow it. She's going to have a straight First Amendment case to the Supreme Court. Every single time they try to ban abortion, they are violating the Constitution because they are violating a Jewish woman's right to the freedom of her religion.
Well, unfortunately, he's wrong. And again, hopefully you guys can see the distinction here. Similar to the first case, the first video we looked at, this would not be a First Amendment violation. There are lots of things that we deem to be morally repugnant and the government prohibits us from doing, even though people might believe that they exist. For example, polygamy is something that Mormons believe, or some sects of Mormonism believe in. Not all of them believe in that anymore, but the government has a compelling interest in preventing people from having many, many wives, and prohibiting that is narrowly tailored to prevent that. Sacrifices are another great example. Human trafficking, just because your religion believes that women are property or something like that, doesn't mean that you can do whatever you want here. Missouri, in fact, even had written into their statutes that certain sex crimes were offenses even if practiced for religious reasons. Perhaps the most grotesque example that has been emerging lately is the concept of female circumcision. This is something that some religions believe you should do, not permitted in the United States, and definitely not going to be something that you can claim religious freedom over. Once again, yes, if you want to go to church, the government can't shut down your church. If the way you want to pray is by singing hymns, the government can't stop you from doing that. If the way that you want to practice your religion is to do nothing, the government can't force you to go to church or can't force you to sing hymns. What they can do is prevent you from doing things that other people find are morally repugnant. With abortion, this is a very sticky issue because there's going to be a lot of disagreement about this. Lots of people disagree. Here, when we talk about abortion, the current law of the land is that it's a state decision. And some states, he is correct, have decided, yes, this is something that our state finds so horrible that we are going to count it as murder, or we are going to penalize it civilly. Insert the response you want here. There's lots of different schemes out there, but the fact of the matter is that until the law changes or until there is some sort of federal law that is, supreme to the state laws, yes, this is, even though it has a religious basis, going to be something that the government can regulate. More to his point, the length of the belief or the time of the belief doesn't matter. The fact that it has been part of Jewish culture for hundreds or thousands of years is irrelevant to the analysis here. Again, I hope you guys can see the distinction. If you don't agree with me, if you want to discuss this, again, great topic for discussion. Finally, this brings up some of my favorite things that we get to talk about, which is your right to privacy.
The difference is Muslim people in our government aren't trying to force the rules of their religion into civil law. Like, Ilhan Omar isn't out here saying the Quran says you shouldn't be gay, so let's make it illegal. Meanwhile, Mike Pence is.
So this is definitely very polarizing. I'm going to skip over the whole concept of cancel culture and talk about homosexuality, which I think is the much more interesting topic anyway. Homosexuality, while possessing a relationship to the free exercise of religion or anti-establishment of religion, really has its protection under your right to privacy. And the right to privacy is one of my favorite constitutional law things. I am sure I'm going to talk about it many more times before now in the time that the semester ends. But let's give you a little bit of background on it. The right to privacy was basically held to exist under Griswold versus Connecticut. The conservative aspects of the court claim that this is a judge-created law, and to a large extent it is. It does not exist in the Constitution. It is not something that the Constitution says, hey, you have the right to privacy. What the judges in Griswold say is that, hey, there's this Bill of Rights thing. And if we read the Bill of Rights, essentially the thing behind all of it, the rationale behind every single right that exists, is this concept of a right to privacy. And there are things that our forefathers were unable to envision when they wrote the Constitution. Their idea was that we would rewrite it pretty quickly. They didn't know that we would keep it for hundreds of years. And so we're going to liberally construe some of the things that they have in it, the Bill of Rights being one of them. So they said that there is a right to privacy. In Griswold, what we have is a married couple whose doctor says, for whatever reason, you all should be on contraceptives. And in Connecticut, that is against the law. You cannot take any action to prevent a pregnancy from occurring. So Griswold gets in trouble. Griswold sues Connecticut. Basically, it makes its way up to the Supreme Court. And the Supreme Court says, look, a married couple doesn't need the government in their bedroom. They can use contraceptives if they want to. They call this the penumbra of the Bill of Rights. The penumbra, if you've had any of my classes before, you know, is that shadow that is not quite in the shadow and not quite in the light. The umbra is the actual shadow. The light is the light. Google it and you will see a great illustration of that, but I neglected to put one in my notes, so you were in charge of looking that up. This right was later extended under a plethora of cases, including famously Roe versus Wade, and when it comes to homosexuality in Lawrence versus Texas. In Lawrence versus Texas, a couple of men were engaging in adult activities in the privacy of their own home. When unrelated, the cops break in. I don't remember what they were searching for, but to execute a search warrant or an arrest warrant. And they find these guys in the middle of what they're in the middle of. In Lawrence, Lawrence was charged with sodomy in that it violated Texas law, basically saying that you may not engage in activities with anyone other than a member of the same sex. But the Supreme Court held that, hey, guess what? No, you have, under the same logic of Griswold, a right to privacy of what you do in your bedroom and with whom you do it. So, interestingly enough, and again, it didn't make it into my notes, one of the things that we need to be on the lookout for in the coming years is the repercussions of the Dowd decision. As alluded to in some of the videos, this whole concept of the right to privacy has been called into question. While the majority opinion expressly states that this only applies to abortion, we're only going to turn back the hands of time on abortion, some justices are calling for a much further reach. Justice Thomas, in his concurring opinion, basically said that we should erase the right to privacy for everything, except for when it comes to interracial marriage. Yes, the right to privacy protects interracial marriage as well, but Justice Thomas says, nope, that's protected, but everything else should go, including Lawrence versus Texas, Griswold versus Connecticut. And that should be kind of scary, because if you want to read the laws of the state of Missouri, for example, pretty much everything except for vaginal intercourse is considered sodomy and a crime. So, you know, it's something where the government has no business being in places that are so intimate, in my opinion, and I think in the majority of our opinion. Yet laws exist on the books that if we were to roll back the hands of time on your right to privacy, a lot of normal everyday behaviors would be exposed that we don't want the government to be part of. Like I said, right to privacy, very important. It's going to come up again, but we're going to move on to the Second Amendment. First off, once again, great work, everybody. I was only able to feature some of the videos. Please keep uploading them. I really, really appreciate those of you who uploaded files so that I can not have to try and download them and stuff like that. Please keep doing that. Next, please submit some Second Amendment videos. I'm going to have these due Wednesday so I can try and get caught up here. You know, just a video or two. Y'all did great with these. And then I'll have your discussion boards due this weekend, so you'll have plenty of time to get that done. So what I'd like you to do is write a discussion board, again, you know, on whatever you didn't like, whatever you liked, whatever you found most interesting as it relates to freedom of religion. Everybody, thank you so much. I hope you're continuing to have a great semester. Please feel free to reach out if you have any questions or concerns. Have a good night. Bye.